Welcome to the Freedom File. I'm Judge Andrew Napolitano. When James Madison was a member of Congress in 1791 and charged with drafting the Bill of Rights, he insisted on two grammatical demands. One was that the word "the" precede freedom of speech in the First Amendment, and the other was language in the Ninth Amendment that rights retained by the people, rights too numerous to enumerate, shall not be disparaged by the government. This principle that our rights preceded the government would be played out over and over in litigation in the centuries following the ratification of the Bill of Rights. The ratification itself was insisted upon by 5 of the new 13 states, who threatened to leave the new union unless restraints were added to the Constitution so as to protect the very individual liberties that the Declaration of Independence, then only 15 years old, stated unambiguously were granted to individuals by our Creator. Though the colonists deeply valued all the rights articulated in the Declaration, truly it was the freedom of speech that drove the revolution. Yes, the Americans had Kentucky long guns that enabled the colonial militias to shoot and kill British forces from distances that the British weaponry was unable to reach. And yes, the Americans were animated by defending their homeland. But it was speech, sung in taverns, written in broadsides, delivered in sermons, distributed in pamphlets, adopted by the Continental Congress and colonial legislatures, and proclaimed publicly in town squares from Boston to Charleston. Speech that whipped the brush fires of freedom into a revolution and a new nation. I offer this brief historical, philosophical, and legal analysis of the freedom of speech as background for what we will now talk about. Today, this most basic and utterly essential freedom, which is both a natural human right and a constitutionally protected right, is under assault by governments that hate or fear the content of speech, what people are actually saying. I am, of course, addressing the demonstrations on college campuses today and the authoritarian responses to them by college presidents, by governors, and by mayors. Here's the dispute as I see it in a nutshell. Students at various universities are repulsed by the gravity of the assault on Gazans by the IDF. They have chosen to address this assault and not the assault on Israeli civilians and military on October 7th. They are free to choose to address whichever assault they want to talk about. They have also chosen to articulate their views by occupying public places on the campuses, shouting, screaming, singing, and haranguing college administrators. The administrators, fearing a loss of donations from those who disagree with the students or harm to other students who might challenge the demonstrators, have engaged local and state police to suppress these demonstrations. Question: can the government interfere with speech because of its content? In a word, no. How about on private property where campuses are not owned by the government? Well, that depends on the location of the campuses, as most states, but not all, have public accommodation laws that make college campuses public places available for the articulation of ideas. And even the colleges in states without these laws that accept federal funds do so in contracts with the federal government, which requires that the colleges respect free speech rights on their property. These public accommodation laws and these agreements with the feds, in my view, are violative of the property rights of the owners of these colleges. Yet, like free speech, property rights too are under attack in America today. Nevertheless, today it is clear beyond dispute that college campuses, the public parts of college campuses, are there for the free exchange of ideas, whether these ideas are approved by the owners of the campuses or not. Question: is speech that preaches hate and threatens violence protected on college campuses? In a word, yes. 2 Supreme Court cases are instructive here. In Terminiello versus Chicago, a 1949 case, a Roman Catholic priest aimed hatred at President Harry Truman, and the hate speech produced violence and property damage. In Brandenburg versus Ohio, a 1969 Supreme Court case, a Ku Klux Klan leader aimed hatred at blacks and Jews. In Terminiello, the violence was caused by the audience members who hated the speech they came to scorn. In Brandenburg, the KKK speaker demanded violence, but it never happened. The Supreme Court sided with both speakers, and the jurisprudence from both cases is now integral to American law. It teaches that all innocuous speech is absolutely protected, and all speech is innocuous when there is time for more speech to challenge it. Moreover, the court ruled, freedom of speech is so essential to human happiness and so integral to democratic values that it even tolerates violence, meaning those who engage in violent acts can and should be addressed by the criminal justice system. But those who preach it and call for it are immune from prosecution unless they cause an immediate, unthinking, violent act, meaning there is no time for more speech to challenge their cause for violence. One can argue, and I believe, that in the case of college campuses today, the violence has been caused by the government. When the property on which the demonstrators stand is owned by the government, like the University of Texas, where the governor sent in police on horseback to rough up peaceful demonstrators, or is privately owned like Columbia University, where the New York mayor sent in police to arrest peaceful students, this is of no moment. No moment because the students have an absolute right to think as they wish, to say what they think, to read what they want, to publish what they believe. And they can do this alone or in groups. They can do it quietly or profoundly. And they can do it with impunity. Anything short of leaving them alone involves the government evaluation of the content of speech, the very acts that the First Amendment was written to prevent. Today, the government wants wars. It's paying for wars. The students want peace. In the bitter days of the 1960s, which I recall, student demonstrators chased an incumbent president, Lyndon B. Johnson, from re-election and chastised a new president, Richard Nixon, into a policy change over the war in Vietnam. Today, the government seems determined to use force to prevent change and to suppress freedom. If the British had done this successfully in the 1770s, we'd all be bowing to Charles III today. Here with me to talk more about this issue is my friend Allen Mendenhall. Professor Mendenhall is the Associate Dean at Troy University and Executive Director of the Manuel H. Johnson Center for Political Economy. He is a lawyer, he's a legal scholar, he's a PhD, and he's a college administrator. And he's my friend. What ideal person to talk about this. Professor Mendenhall, welcome to the show. Give me a critique of my understanding of the freedom of speech, Professor.
Well, in a universe of purely private interactions, speech regulation is pretty straightforward. If you come into my house or my business and insult me, I can tell you to shut up. I can tell you to leave. No problems there. The issue becomes the involvement of government. So the First Amendment prohibits only government-imposed speech restrictions. Many private universities commit to safeguarding speech in their policy manuals, in their conduct manuals, in their promotional materials. And in that case, those universities have to be held to the standards that they set for themselves. But the First Amendment also doesn't shield students from criminal liability for acts like theft or vandalism or destruction of property, assault, battery. Committing crimes does not fall under First Amendment rights, and students can't evade punishment for such actions. So if students are peacefully protesting, no issue there. The government has to leave them alone. Universities have to leave them alone and enable them to express themselves.
Professor, how about if the students are peacefully demonstrating, but they're saying things that are incendiary to certain groups, really incendiary and hateful? I don't want to repeat them here, but the audience can imagine, and you can imagine what I'm talking about. I would argue, and tell me if you agree, that even that speech is protected under the First Amendment, because that's what the Supreme Court said in Terminiello and in Brandenburg.
Yes, that's correct. That speech is protected. Now, an analysis of whether any particular utterance is constitutional or not is highly contextual. So there's something called an illocutionary act, which is I am expressing myself by acting a particular way, like burning an American flag, for example. If I were to do that in a public space, then my action, my expression would be protected. But if I were to walk over to my neighbor's yard and remove a flag from his porch and light it on fire, that would not be protected because I'm not in a public space, I'm trespassing on someone's lawn, I'm destroying someone else's property. So the exact same act can be constitutional in one context and unconstitutional in another context. So if I am issuing hateful words on, let's say, a quad in a university, that speech would be protected. But if I'm part of a mob and I'm surrounding a Jewish student and preventing that Jewish student from going to class and taking a final exam, and I'm yelling racial slurs, well, that is an unwarranted act of intimidation. That is where a line has been crossed. So you have to analyze a lot of these situations.
Got it. There's a lot more I want to ask you about, and I want to talk to you after we take the break about your role as a college administrator and how you would address the very things that we're seeing every day. So we'll continue our discussion on free speech with Professor Mendenhall in just a moment. That's next. We're back with Professor Allen Mendenhall. Professor, you are a lawyer, a legal scholar, an economist, a PhD. You are also a college administrator. What is the problem? What do college administrators think if 25 or if 2,500 students are in a public place on a college quad or square chanting and screaming some political view? Do administrators care?
Yes, they do. And ideally, they already have in place policies that address these issues and can be followed, lawful policies. So in general, universities want to define speech broadly, but then enforce their policies neutrally. Government institutions can regulate the time, place, and manner of speech. And some of these regulations are actually designed to protect more speech, for example, to prevent a heckler's veto. So a university can prohibit students from deplatforming or shouting down a speaker, for example, who holds unpopular views, because they are trying to promote the speech of the speaker. So there are legitimate regulations, and universities are, of course, interested in promulgating rules that are fair to all sides and that promote as much speech as possible. Is it
lawful for universities, in your view and from your experience as a professor and a college administrator, to use force when there is no violence on the campus, when no matter how incendiary the speech is, nobody's physically resisting it?
No, that is not lawful. And in fact, our free speech rules that have come down primarily through 20th century court precedents and legislation generally reflect the sort of libertarian view that so long as particular speech does not infringe upon the rights of somebody else, it's permissible. Once speech infringes upon the rights of somebody else, it's not permissible. I don't have the freedom to go into a public highway and protest there and prevent ambulances from getting people to the hospital who've had a heart attack, or women to the delivery room who are in labor. That type of speech infringes upon somebody else's rights. Right. And in general, our laws reflect that reality.
Professor Mendenhall, it's a pleasure, my dear friend. Thank you for joining us. Thank you for the extra time you spent with us. I hope we can do it again. And now I think you're going to go to the golf course.
I'm actually at a conference, Judge, but there is a golf course out the window.
Thank you, Alan. All the best, my dear friend. Of course. The gag order from a judge doesn't seem to be stopping former President Trump from speaking his mind. We'll talk about the impact that has on the jury next.
This judge, who's totally conflicted, has me under an unconstitutional gag order. Nobody's ever had that before, and we don't like it, and it's not fair. I'm not allowed to talk. There's never been any abuse like this before. This conflicted judge ought to get out of this case. He should not be having this case.
Welcome back. As the Donald Trump criminal trial continues, the recent contempt hearing puts a renewed focus on the former president's statements and on the freedom of speech. It seems that everything Donald Trump says outside the court is getting scrutinized. And of course, as you know, Justice Juan Merchan threatened that Trump could be incarcerated if he violates the gag order that the justice imposed upon him. There's also concern about what the president might say if he testifies on the witness stand. Here to talk more about that with me is my esteemed colleague and the great criminal defense lawyer, Arthur Aidala. Arthur, great to have you back on the show. Thank you, my dear friend. So first of all, the gag orders. What is accomplished from the government's perspective with these minuscule $1,000 fines? I mean, right now it's $13,000 to a billionaire. Is there some method to the government's madness? Each time they present another violation of the gag order, the judge holds a hearing, he agrees with the government, he fines the defendant $1,000. Where are they going with that?
I just think it's a fly in the ointment. I don't think it has any real effect on the jury. I think they're trying to keep Trump in check. Look, he's got a very powerful megaphone. I'd have to say the biggest in the world almost right now, maybe him and Taylor Swift. And I'm actually not being facetious about that. So they don't want him to really tamper with the witnesses. But most importantly, it's really the jury. And even yesterday in the proceedings, the judge of the 4 comments, 2 Cohen, 1 Pecker, but the 1 jury comment, that's what he was focused on. And look, they lost 1 juror, I'm sure you remember, Judge, right after they were picked, saying, people were able to identify me and there's too much pressure. So you never want to put pressure on a jury. But I don't think the gag order is really going to have a big effect on the case, especially, Judge, if the jurors are abiding by the judge's instructions not to listen to any outside voices regarding the trial. So they're not supposed to look at social media, newspapers, news reports. So they're not supposed to know what anyone says outside of that courtroom. It's more difficult now than ever for that to happen. Okay. But to your point, obviously $13,000 is not going to mean anything to Donald Trump. But since those first violations, I don't believe he's committed any other violations.
See, I think the government is trying to pile it on. I mean, $13,000 means nothing to him, but once it gets up to about 35 or 40 different violations and he keeps paying the fines, I think the government will go to Justice Merchan and say, look, your fines aren't working. You gotta turn up the heat. But we'll see what happens. I want to talk to you about.
I don't think they want him to go to jail at this point. I don't. I think they think that they're feeding right into.
Then they should be careful what they ask for, as you know from your own experience. But I want to talk to you about his comments in the hallways as he's entering the courtroom and as he's leaving. Isn't this a form of testifying? Isn't this a form of getting a message out that he hopes and expects the jury will hear? And don't we all know that jurors are human beings who are going to turn the television on when they get home at night?
Well, I wouldn't say it's testifying as much as commentary. So he's not that much getting into this is my relationship with Stormy Daniels, or this is how the bookkeeping was done. It's more of, I can't get a fair trial. These jurors are all Democrats and they're all against me. The judge is totally conflicted. That's been his message all along. And the gag order is absolutely unconstitutional. So it's not really testimony that he's giving. He's not going up there saying, I couldn't have been with Stormy Daniels because I have records that shows I was in Italy when she's saying I was with her. It's more of his commentary about the unfairness of the trial. And yes, if someone on the jury is listening to that and watching that, but they shouldn't be, it could have an effect on them.
Is he running the risk in making these outside the courtroom, literally right outside the courtroom statements, of making an admission of trying to summarize something or state some view of his evidence as he saw it? And if it is an admission, can't the government use it against him?
Absolutely, 100%. Yes, 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 yes. And when you're a defense attorney, those are the worst things, Judge, because you can't cross-examine a videotape or audio tape of your own client, right? You can't. It's very hard. What you have to do, I've been in that position, you have to then parse every word, break down every single word, every syllable in a word to see if you could spin something that your client may say that's against his interests and spin it so it's in his interests. Yeah, I mean, look, Judge, I don't want to sound like a braggart, but the Trump people have called me 3 times to represent him on 3 different matters. And one of the real legal reasons why I'm turning it down is my firm represents Rudy Giuliani on several matters regarding where his lawyers of record in the Georgia case. We're handling his getting disbarred or suspended from the bar. So that I don't want there to be any conflict. But also, Judge, I need to have a client that I can control.
Well, that was
Rudy
my next
Giuliani,
question.
Alan Dershowitz,
But you have represented very high-profile clients. We got about 45 seconds left. How in God's name do you silence them?
You beg. You beg, you plead, and you say, this is not in your interest. You're not helping yourself. You think you're helping yourself, but you're not. And look, Rudy's a lawyer, Alan's a lawyer. They actually wind up listening sometimes.
All right. Arthur, thank you. You beg. I want a picture of you begging, but thank you. You're right. What else are you going to do? Thank you, my dear friend. Always a pleasure. All the best to you.
Pleasure's all mine.
You got it. That's my show for this week. I hope you enjoyed it. Thank you for watching. Have a great weekend.